I'm here at Disney, where they've just announced the construction of their new theme park. It's called Villains Land. It contains all the classic Disney villains like Darth Vader, Scar, Cruella de Vil, and the lawyers from White and Case who represent Disney, who are seeking to compel arbitration of a plaintiff who died of an allergic reaction at a restaurant in nearby Disney Springs. As you might have seen on social media, Disney's lawyers claim that because the husband signed up for a free trial of Disney Plus 3 years before his wife died, they've waived their day in court and the claims must be arbitrated.
Sure, that sounds bad, but what if I told you it was actually quite a bit more complicated than it seems? Now, by the end of this video, you might not agree with Disney's lawyers, but you'll at least understand their arguments. But the optics were so bad that after days of backlash, Disney backed down and waived its right to arbitration, meaning the family will get its stay in court. But that doesn't mean that Disney is cutting its arbitration clause from its terms of service, or that this issue won't recur again. So do you really sign away your right to ever sue Disney by becoming a Disney Plus subscriber? Today we will delve into whether it really is a litigious world after all. But here are the facts as alleged in the complaint. On October 5th, 2023, Jeffrey Piccolo and his wife, Canuck-born Tong Swan, had dinner with his mother, Jackie, at Raglan Road, an Irish pub located on the Disney Springs property in Orlando.
I'm here at downtown Disney, which is a lot like Disney Springs, except it's next to Disneyland instead of Disney World, because I didn't want to schlep all the way to Orlando for this bit. Unlike the restaurants inside of the theme parks, like say the Magic Kingdom, Disney doesn't own and operate all of the shops and stores at Disney Springs. It's more like an outdoor mall. Disney owns the land, but they lease that land back to the stores and individual restaurants that then operate them fully independent. Instead, Disney leases the commercial space to brands like the House of Blues or the Earl of Sandwich. According to Disney, the Irish pub, Raglan Road, is owned and operated by co-defendant Great Irish Pubs Florida. Disney leases the commercial space to Great Irish Pubs.
But the briefing alleges that Tang Swan was a medical doctor at NYU Langone in New York and knew she had a severe allergy to dairy and nuts. Before going to the restaurant, her husband, quote, relied on allergy-related acknowledgments, representations, and advertisements about Raglan Road on the Walt Disney Parks and Resorts website. The Disney Parks and Resorts website displays Raglan Road's menu, which includes the alleged representations. When the waiter came to the table, Tong Swan and Piccolo advised the waiter that she had severe food allergies and required allergen-free food. The waiter went to the chef to ask whether certain foods could be allergen-free. When the waiter allegedly returned to the table, he told him that the chef would prepare an allergen-free meal. Quote, to be absolutely sure that allergen-free food would be served, Tong Swan and Piccolo questioned the waiter several more times to confirm the food Tong Swan was ordering was allergen-free. The waiter unequivocally assured them that the food would be allergen-free. Tong Swan apparently ordered, sure, I'm frittered, scallop forest, this shepherd went vegan, and onion rings. When the server brought the food, some of the items did not have allergen-free flags in them. Tong Swan and her husband asked the waiter whether all the food on the plate was allergen-free, and the server confirmed that the food met her dietary requirements. After the meal, Piccolo went back to his hotel and Tong Swan and Jackie went shopping. Less than an hour later, Tong Swan entered Planet Hollywood while suffering from an acute allergic reaction. She began having severe difficulty breathing and collapsed to the floor. Someone called 911 and told the dispatcher that Tong Swan was having a severe allergic reaction and had emergently self-administered an EpiPen. But Tong Swan died at the hospital. The medical examiner's investigation determined that Tong Swan's cause of death was as a result of anaphylaxis due to elevated levels of dairy and nuts in her system. So Piccolo filed a wrongful death action against Raglan Road at Walt Disney World Resorts on February 22nd, 2024. The theory of liability against the restaurant was incredibly straightforward. They alleged that the restaurant was negligent. Raglan Road owed a duty of care to its customers to ensure that the food that was designated as allergen-free would actually be allergen-free. And it allegedly failed in this duty of care by serving contaminated food. But not surprisingly, the plaintiffs wanted to bring in the deep pockets of Disney into the lawsuit. But that was more complicated. The complaint says that Piccolo relied on the Disney website's representations that restaurants and its physical properties could accommodate allergies when they made the decision to eat at Raglan Road. The complaint claims, quote, Disney advertises and represents to the public that food allergies and or the accommodation of persons with food allergies is a top priority at its parks and resorts, including Disney Springs, and that patrons/guests may consult with a chef or special diets trained cast member before placing an order, and at all times material plaintiff relied upon these representations in selecting Disney Springs Raglan Road for dinner. Now, I don't know what the Disney website said back in October of 2023 because the Wayback Machine doesn't have the images of the Disney Parks website archived. But if you go to the Disney website now, you can click to read Raglan Road's menu, which makes the same representations cited in the complaint. But the Disney page does currently contain a disclaimer that they can't guarantee food is free of allergens. Clicking on the link for Raglan Road does not actually take you to the restaurant's website, and the Raglan Road menu wasn't archived either. However, after Piccolo filed his lawsuit, the company added a disclaimer to the website. We are not a gluten allergen-free restaurant. We cannot guarantee that any dish we prepare is free from gluten allergen or free from cross-contact. Guests must notify their server of any allergy-friendly request. A manager will then discuss our allergy menu with you, etc., etc. So that takes us to the litigation that created a PR nightmare for Disney. On April 11, 2024, counsel for Disney entered its appearance in the state court case. The Disney lawyers prepared discovery requests and filed an answer denying liability. Now, Disney's initial answer did not include an affirmative defense that the case was subject to arbitration. That came back to bite them because the plaintiff argued that they waived the right to arbitrate because they didn't include it in the answer itself. But Disney amended its answer as a matter of right, so that probably wouldn't have flown. So on June 3rd, 2024, Disney filed a motion to compel arbitration in state proceedings, arguing that the estate of Ms. Tongswan must arbitrate its claims because, one, Mr. Piccolo in his individual capacity back in 2019 allegedly agreed to arbitrate any dispute against WDPR, World Disney Parks and Resorts, by signing up for a Disney Plus account on his PlayStation, and two, Mr. Piccolo in his individual capacity prior to his wife's passing used the WDPR website to purchase tickets to Epcot, which were never used. Now, many people incorrectly reported on this whole incident by claiming that Disney was seeking to dismiss the case entirely because of the arbitration provision. And that's not exactly right. While it is true that you dismiss the state court case, it then goes to arbitration, where there would be a full verdict on the merits. Arbitration is a form of alternative dispute resolution, ADR, where the parties agree to submit their conflict to one or more arbitrators instead of going to court. While arbitration is often maligned in the media, often it can be just as good as state court, and often in many ways much better. It can often be much faster because you're dealing with private parties, as opposed to a state court judge who might be absolutely swamped. The proceedings can often be much more circumscribed, which means it's often much cheaper to arbitrate rather than proceed with a state court lawsuit. And sometimes the arbitrator, who fills in for the role of the judge, is a subject matter expert as well, so they might be much more familiar with the subject matter of the lawsuit. But on the other hand, one or both of the parties are going to have to pay the fees of the arbitrator, where you wouldn't have to pay the fees of a judge. And sometimes what happens in arbitration is often not public record. But whether a party has agreed to arbitrate an issue is simply a matter of contract interpretation. You just look at the contract that the parties have signed and see if the arbitration clause covers that situation. A party cannot be required to submit to arbitration any dispute which he has not agreed to so submit. And although the intention of the parties is controlling, the Supreme Court and courts in general favor arbitration. So any doubts concerning the scope of the arbitrable issues should be resolved in favor of arbitration. And there's federal legislation in the form of the Federal Arbitration Act, which creates a strong presumption in favor of arbitration. And the reason is that Congress and the courts want to get cases out of the clogged court system and into arbitration if the parties have so agreed. Arbitration awards are generally final and binding, meaning that they're hard to get overturned by the courts. Though it is true that many plaintiffs want to avoid arbitration because, one, fair or not, arbitrators have a reputation for being more conservative when it comes to payouts to plaintiffs. And for reasons that I've never found compelling, the courts do allow a class action waiver in arbitration. Though that has come back to bite many large corporations, which included a class action waiver, because then they had to arbitrate thousands of individual arbitrations instead of just dealing with one class action lawsuit. Though that is not at issue in this particular case. Now, if you've used any website, you've definitely agreed to a mandatory arbitration without knowing it, often because many arbitration clauses are located in the fine print of the terms and conditions. And arguably that's what happened here. Piccolo signed up for Disney Plus, which included a click wrap agreement, which happened to contain an arbitration clause.
Now, if you or a loved one has been injured at a Disneyland-themed resort, you're going to need a good lawyer because they hire really good lawyers. But if you want a great lawyer, my firm, the Eagle team, can help.
Yeah, if you've gotten in a car crash in a Disney parking lot, were injured on a Disney ride, or suffered a data breach from your Disney Plus account, or are dealing with any non-Disney related issues, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can get the best representation, maximize your recovery, and find out what your options are. So just click on the link in the description or call the number on screen for a free consultation with my team.
Because you don't just need a legal team, you need the Eagle team. Now get me out of here before Disney finds me.
But the main question here is, did the parties agree to arbitrate this particular dispute? In this case, Disney cited two arguments that would have compelled arbitration. First, Disney argued that Piccolo agreed to arbitrate when he signed up for a Disney Plus trial in 2019. And second, Disney claimed that by purchasing Epcot tickets in 2023, they reaffirmed their agreement to the terms of use arbitration clause. Now, when you sign up for Disney Plus, you create an account, and that account will be the same one that you use to purchase any Disney product. And when you create that account, you have to agree to the terms of use. The terms of use require you to arbitrate disputes. Here's the Disney Plus arbitration clause. You and Disney DTC agree to arbitrate as provided below all disputes between you, including any related disputes involving the Walt Disney Company or its affiliates that are not resolved informally, except disputes relating to the ownership or enforcement of intellectual property rights. What disputes? Dispute includes any dispute, action, or other controversy, whether based on past, present, or future events between you and us concerning the Disney services or this agreement, whether in contract, tort, warranty, statute, regulation, or other legal or equitable basis. What are Disney services? The terms of use define Disney services as sites, software, applications, content, products, and services. Now, based on this broad language, Disney argued that the current case fell under the arbitration clause and had to be arbitrated. And in fact, even before getting to the question of whether the dispute was arbitrable, Disney argued that the arbitrator had the exclusive authority to resolve any dispute relating to the interpretation, applicability, or enforceability of these terms. Meaning that based on the contract, Disney was arguing that the case had to be taken out of state court, put before the arbitrator, who then decided whether the arbitration clause was broad enough to encompass the current dispute. Now, that's not unusual at all. Arbitrators make those kind of decisions all the time, and people often write arbitration clauses to make that kind of determination. And by now you're probably starting to piece together why Disney's argument wasn't so crazy as it first appeared. There's little doubt that the restaurant itself would probably be liable if the things alleged in the complaint are true. But Disney didn't own the restaurant. So the plaintiffs were trying to create what's called agency liability between the restaurant itself and Disney through the representations on the Disney website. And that's not crazy either. Disney allegedly made a whole bunch of representations about the allergen-free nature of the food or accommodations that could be made, and that could make it liable for the damages that the plaintiff suffered. But those representations came by way of the Disney website, and the Disney website is much closer in concept to Disney Plus and the Disney accounts than a physical restaurant would be. And Disney was arguing that the same terms of service between the Disney Plus account and accessing their websites applied. And there's at least a colorable argument that the definition of disputes and Disney services covers the kind of backdoor liability through the Disney website that the plaintiff was trying to create. And it wouldn't be a question of either the restaurant was liable or Disney was liable. The plaintiff was just simply trying to bring both in, which is again a totally normal thing for a plaintiff to want to do. Now, obviously Piccolo argued that his wife's estate should not be bound by the arbitration agreement. He argued that even if the arbitration agreement was valid, it only covered disputes involving Disney Plus and not anything involving Disney parks, which is probably what most people thought when they heard the top-level headline related to this story. He also argued that the arbitration agreement was unenforceable because he had no actual or inquiry notice of the terms of use on the Disney website because the website didn't reference them or hyperlink properly. And he also argued that the clause conflicted with other terms and conditions that made it ambiguous. But a lot of people claimed that this interpretation of the arbitration clause was too broad and draconian and therefore should be considered unconscionable. Now, an arbitration clause may be considered unconscionable and thus unenforceable if it's deemed to be excessively unfair or oppressive to one side. And Florida courts look to both the procedural unconscionability, which is the process of contract formation, and substantive unconscionability, which is the fairness of the terms themselves. And Piccolo argued that the terms of use were effectively buried within another document that was hyperlinked, and once the links to either of the agreements were clicked, the links merely direct the customer to agreements which contain the binding arbitration provision amongst many pages of other terms and conditions. There was no mention or warning on the internet screen of the Disney Plus registration page, noting that the terms contained any binding arbitration provision or required a waiver of the consumer's legal rights. And as for substantive unconscionability, Piccolo said that the clause was so draconian that it would bar any legal action against any Disney affiliate basically forever. However, Disney also had some significant case law on its side. The plaintiff argued, quote, "In effect, WDPR is explicitly seeking to bar its 150 million Disney Plus subscribers from ever prosecuting a wrongful death case against it in front of a jury, even if the case facts have nothing to do with Disney Plus." And that is one possible outcome here, though, as we've discussed, the facts in this case aren't exactly the same. This is not the most extreme case of someone who signed up for Disney Plus, then went to, say, a Disneyland resort, and then was injured by the negligence of a Disneyland employee, and then Disney using the arbitration agreement of the Disney Plus agreement to force arbitration. Here, the facts are a little bit removed from that. And other jurisdictions have found that even in more extreme circumstances, the arbitration clause does apply. For example, in 2020, the Fourth Circuit Court of Appeals dismissed a class action against AT&T, which involved some of the same issues. In that case, the plaintiff Diana May sued DirecTV over alleged violations of the Telephone Consumer Protection Act, or TCPA. May claimed that DirecTV made unsolicited marketing calls to her despite her number being on the National Do Not Call registry. But DirecTV sought to compel arbitration based on an arbitration agreement in May's AT&T mobility contract. What's interesting is that May signed the AT&T contract before AT&T purchased and acquired DirecTV. but the Fourth Circuit ruled that DirecTV, as a then affiliate of AT&T, was included within the entities covered by the arbitration agreement. But apart from Disney+, Disney also claimed that when the plaintiffs booked a vacation and purchased Epcot tickets in 2023, they affirmed their agreement to the terms of use arbitration clause. And that's because when Piccolo purchased park tickets, he had to use the Disney Plus account he created back in 2019. Disney says that by logging into the site in 2023, the plaintiffs agreed to a web form that included a checkbox that states, "I have read and agreed to the My Disney Experience terms and conditions." Piccolo selected the checkbox and agree and continue directly below the disclosure. Now, Piccolo and many in the media characterize Disney's position as any person who signs up for a Disney Plus account, even free trials that are not extended beyond the trial period, will have forever waived the right to a jury trial enjoyed by them and any future estate to which they are associated, and will instead have agreed on behalf of other survivors and the estate itself to arbitrate any and all disputes against any and all Disney entities and affiliates, no matter how far removed from use of the Disney Plus streaming service, including personal injury and wrongful death claims. And that is one particular outcome, but a more generous reading of the Disney position is that the arbitration clause would have applied in this case because plaintiffs' theory of liability against Disney parks relied on agency law. When the Piccolos visited a Disney property, Disney Springs, they reasonably believed that Disney had control and authority over the preparation of the allergen-free food. Quote, defendant Disney made aforesaid acknowledgments and representations on their website regarding their commitment to providing allergen-free food and/or accommodating patrons, customers with allergen-free food at all of Disney's properties, including Disney Springs, where the Raglan Road restaurant resides. But in any event, the public outcry was incredibly severe. And in dropping its arbitration demand, Disney portrays itself as the friendly company next door who does not want to blow your house down. Quote, at Disney, we strive to put humanity above all other considerations. With such unique circumstances as the ones in this case, we believe the situation warrants a sensitive approach to expedite a resolution for the family who have experienced such a painful loss. As such, we've decided to waive our right to arbitration and have the matter proceed in court. So Piccolo will now proceed with this lawsuit against Disney in Florida State Court. The estate is seeking damages in excess of $50,000 pursuant to Florida's Wrongful Death Act. They're not seeking only $50,000, that's the minimum that they're seeking, as well as damages for mental pain and suffering, loss of companionship and protection, loss of income, and medical and funeral expenses. But this doesn't mean that the company would not try to use its arbitration gambit in another case. Disney said it would waive its right to arbitration in this case only. So, for better or worse, this case will now be resolved in the Florida State Courts, probably sometime in 2030. Now, if you're looking for a great meal but want to avoid eating on any of the Disney properties, you can with today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things that you actually want to do. And I can personally test the meals are fantastic. You can eat stress-free this summer, plus you'll never get bored with what you're eating. You can choose from over 35 different options a week, including ones that are keto, calorie smart, vegan and veggie, and more. And on top of that, Factor offers lots of snack options for when you don't feel like eating a full meal, like breakfast options, smoothies, juices, small bites, and more, just to keep going no matter what's on the schedule. Factor meals arrive at your door pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I could even think about going to the grocery store, my Factor meal is already done. Because sometimes I just want a good, healthy meal without having to cook. It's the perfect workday dinner. And it's surprisingly affordable too. It's way less expensive than takeout or those pricey delivery apps, plus it tastes way better. And now Factor also offers Gourmet Plus meals as part of your weekly options. You can try meals that feature premium ingredients like filet mignon, shrimp, truffle butter, and asparagus. And maybe it's just me, but I'm always down for surf and turf without having to leave my house on a Tuesday evening. Always. But honestly, you can't go wrong with their normal offerings either. Factor's team of gourmet chefs creates each meal to help you feel your best all day long, and they really are extremely delicious. And Factor is flexible. You can pause or reschedule your deliveries at any time. Now, all this is making me hungry, so click on the link below or the link that's on screen and use the code LegalEagle50 to get 50% off your first Factor box and then 20% off your next month of orders. Again, all you have to do is click on the link and use the code LegalEagle50 for 50% off your first Factor box and then 20% off your next month of orders. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.